Any mention?
Item number 14. 14, 1 for your lordship. Lordship, be kind enough to grant me some time, lordship. 2 weeks time, lordship. Hurry up.
Your Lordship, I beg to mention item number 7.
Yes.
I require at least 2 weeks.
Oh, that is. Mr. Guru was appearing.
My lord, Mr. H. Karmi is for the state. He's the state prosecutor. No, we will inform him, my lord. No objection.
This was hard, I think, for some. After 2 weeks at the request. Yes.
May I please, Your Lordship? I beg to mention item number 18 and 19, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
Other side? No. 18 also. 2 weeks at the. Yes.
Similar prayer for item number 20, Your Lordship.
Item number?
Item number 20, Your Lordship.
20 is the other side.
My lord, I'm for the other side.
Yes.
20.
No objection.
No objection, my lord.
Okay. 20 also. Same order. Yes.
Highly obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 8 on behalf of Mr. Eston.
Yes. You are making a mention on behalf of the state.
Lordship,
Yes.
I pray for 2 weeks' time, my Lord.
Yes.
Lordship, no objection, Lordship.
This also 2 weeks at the request of the state respondent. Yes.
Much obliged. My Lordship, similar prayer for item number 20, my Lord.
Item number?
20.
20.
Lordship. Oh, Lordship, yes, already mentioned. My apologies.
Lordship, may I please, Lordship, I beg to mention item 15. I pray it may be passed over for tomorrow, Lordship. Couldn't prepare, unfortunately.
Who's the other side?
My Lord, I for the state.
This was the POXO matter heard last time, Lordship. Part heard. Kindly have it tomorrow, Lordship.
Okay, 15.
Tomorrow.
That's all for the day. At the request of the.
Much obliged.
Much obliged. Yes.
May please, Your Lordship. I beg to mention item number 13, Your Lordship. It's a joint prayer from both the petitioner and respondent side.
Yes, Lordship, it's a joint prayer.
Yes.
For 2 weeks, Lordship.
Just say on the joint request of the parties. This up to 2 weeks. Yes.
Deeply obliged.
May please, Lordship, I beg to mention item 11. Lordship, I pray for 2 weeks' time. In this matter, Lordship, settlement process is going on.
My lord, so far as the settlement information which have been submitted, we have sought instruction from the district offices, my lord. But the office seems to have no knowledge about the settlement. However, we have been informed by Mr. Gautam that it is from the higher level. So if
You have no reach to the higher level.
my lord, this is what they are submitting, so we have been requesting them also if we can substantiate that with us so that we can also take necessary instructions.
Contact your
So
higher official and just
we
see.
can, my lord, but then the district offices are not aware in which actually the settlement should have been taken place.
Verify. It's our official things.
My lord.
There will not be much difficulty to find.
My lord, if to that effect an order can be passed, my lord, then we can also.
Even for you, for taking instruction, you need order from this court.
My lord, this have been coming from the petitioner's side, my lord, not from our side, the settlement.
See, if there is just you verify. If there is no talk of compromise, then you make a submission. We will say that there is no compromise.
My lord, we'll take
Then it is, yes,
then my
that
lord,
is what you take a definite this thing.
my lord,
And if they say from higher official, verify who are
that
the
is what they
officials,
have
you do not
informed
need any
us.
order from this court.
My lord, we will verify the.
You just say on the request made by on the joint request made by the parties, this matter. Yes.
Obliged, Lordship.
Please, Your Lordship, I beg to mention item number 6.
Item number 6.
Yes, Your Lordship. Lordship, let it come after 2 weeks.
Why?
Mr. Day is on sanction leave, Your Lordship. Mr. Day is on sanction leave.
Item number 6.
Yes, Your Lordship.
Mr. Day is appearing for?
Petitioner, Your Lordship.
Item number 6 is not Mr. Paul's matter.
Item number 6, my lord, it's our matter.
My apologies, Your Lordship. It's item number 9. Number 9.
Yes, who is the other side? Item 9. No objection.
No.
Item 9. That also had the request for 2 weeks. Yes.
Oblige.
Your Lordship, similar prayer for item number 12.
No objection, Lord.
This 12 will be respondent.
Yes, Your Lordship.
Yes, 12 also had the request of the respondent. Number so and so. Is respondent of what? All the respondents. They are appealing for all the respondents.
Yes, Your Lordship. The District Council.
There is no private respondent in 12.
No, Your
Lordship.
Lordship.
Okay. This also. 2 weeks. Yes.
Any objection?
Oblige, Lord.
May it please, Your Lordship. Lordship, I beg to make a mention item 21.
Item
21, Your Lordship.
21.
Lordship, I'm appearing on behalf of Miss Ardata, Your Lordship. She's a legal aid counsel, Your Lordship, in this matter.
Okay, who is the other side?
And
No objection. When do you want?
2 weeks, Your Lordship.
21. At the request made on behalf of so and so, not a legal aid counsel. Okay. This matter after. Yes. Yeah.
Duplicate.
Daily causeless. Item number 1.
Yes.
Your lordship, the counsel for the petitioner here is indisposed. So I kindly pray for 1 week.
She's
Basically, they are asking for bail. Well, basically, they are asking for bail. So it came on last occasion also. There were some mistakes in the
if it's a
pages.
prayer for bail, can this court? This has to go to the appropriate bail.
By way of 482, they are asking for bail. Basically,
Squashing of orders.
Any bar in doing this? This petition maintainable.
I'll place the material, my lord. They moved the bail, my lord.
What is your stand? Apparently, 482 will not be maintainable in this.
That's one on merit also, my lord. My
But then
stand
that is not very.
It's a commercial
that is not a
quantity,
very
my
strong point for you. Your appearance is so. Anyway, we'll just have it after a week. But just say at the request of the petitioner, list after a week. Yes.
lord. They moved bail, my lord. It was rejected by this honorable court, my lord. Now they've come. Can they be permitted to do that?
It was rejected.
They withdrew it, my lord. In the course of hearing, they saw that there is nothing happening. So
Then now the change came under 482. We'll see.
Deeply obliged, your lordship.
Item number 2.
Your Lordship, in this matter, we are filing our show cause and a no objection application positively today, Your Honor.
Supposed to?
Your Lordship. Show cause to the...
Your Lordship, my rights was closed. So Your Lordship recollects.
Oh, there is a, or there is an order of ex parte proceeding.
Your Lordship. So I file an
We're
application.
filing positively today,
If Your Lordship recollect, on the last occasion, a colleague of my friend here had stood up and made a submission that they're filing it on that date positively, if not on Monday.
Yes.
That was, the matter was listed on Friday.
But due to unforeseen events, Your Honor, we were unable to do so. Today, positively, Your Lordship.
This is not something.
Every time and again, they've made the submissions
It's already under
What is the order sheet?
process filing.
Order sheet is on this. No, it was on the last. It is the last thing. Normally it says another one next time.
Yes, yes. The submissions, I'm trying to
Okay, it was
recall the
not-
submissions which they have made.
It was not
submitted.
recorded. So once it is not recorded, we can
Absolutely, Your Lordship.
also- Anyway,
We'll be filing it positively
we
today.
can record that we will be filing it during the course.
Yes,
of the
yes.
day. Mr. So appearing for the, this will be in the miskis, huh? Order will be in the miskis number 51. Appearing for the applicant, he submits that the objection on behalf of the opposite party number 1 will be filed during the course of the day. Yes, in view of the submission, this matter after a week. We'll have it after a week.
Obliged.
Item number 5.
The end of the board. Your Lordship, this matter may be taken up at the end of the board, Your Lordship.
Why?
Because that Sen Gupta is on leg before.
You are there.
The record has come, so he wanted to argue this matter.
What is the matter about?
This matter relating to land acquisition matter, where Lordship called for the instruction with regard to the date of payment of the
There are
award.
a number of matters involving land acquisition. The court is basically confused. Then we have to.
Earlier occasion, they produced the award paper. In the award paper, date of the award was not mentioned. So Lordship
Is it
directed
the
them
case
to.
where you said that section 9 notification was issued to you?
Yes, yes.
Okay. You have any problem at the end of the board?
But not, I won't have any problem.
You do not have a problem?
Yes.
This is also at the end of the board.
Hello, Blech, Your Lordship.
The end of it.
Item number 6.
Yes.
But in this matter, the bank was supposed to come with instructions today.
May I please, Your Lordship?
That is what is that thing? That defaulter part.
Defaulter.
Okay. Yes. Now the amount has been repaid, isn't it?
Yes, Lordship.
Then what is the
They
problem?
will, let me
we
come
can,
to
we
the
can,
fact
we can
of-
allow their prayer.
Yes, Lordship, they can file a representation, we will proceed.
No, what is the problem if we do it here?
Lordship, that there is a technical problem, Lordship. Let me first clarify. The thing is that the original company, which is R&B Siemens, for against which the present petitioner stood as guarantor.
Can you be a bit louder? See, I don't know.
Lordship, there is sound problem. Lordship, can you hear me now, Lordship?
We can hear you, but then your voice is very low. Sometimes it goes missing.
Lordship, I'm trying to. Lordship, can you hear me now? Am I
Yes,
audible
yes.
now?
Yes, please.
So it so happened that the present petitioner, among others, has stood as personal guarantors to a loan availed by one of the one company, that is R&B Siemens, Lordship, from different banks, including the present respondent bank. Now there was a consortium finance, and after during the course of time, the company failed to pay the outstanding dues, and their accounts stood classified as NPA. Then what had happened, we had proceeded to file an original application before the DRT. Then the consortium lead bank, that is the SBI, and the respondent bank went to the NCLT for liquidation and resolution. At that point of time, it was settled, payment came up, and the matter was settled. And on most of the banks have got their dues, including my bank, the respondent bank. Now, what has happened? The defaulter notice, the willful defaulter notice was issued during the pendency of those those proceedings, Lordship. Now, we had forwarded those things to the RBI, and there is a procedure, entire procedure is there. So, if the now question is that since they have got nothing to pay, we have to remove the name of the petitioner from the defaulter notice. So it can be done only when they file a representation.
No, is it not good enough? Once this amount stands liquidated, then what remains? The person doesn't remain a defaulter anymore.
No, I understand, Lordship. That we are not denying the fact.
Then?
We are not denying the fact, but a procedure has to be followed because it is not in our hand.
Where is the procedure? There is a written procedure for doing this?
Because, Lordship, at this moment I cannot praise, but what I've been instructed is that simple.
No, but then you just praise it. Until and unless there is some requirement in law, then why the petitioner should be subjected to go through all those things?
No,
it becomes a common, it's a very simple thing. They were defaulter maybe at some point of time, but then once they make the payment, that goes. That tag of
no, Lordship, I understand. Lordship, I understand. The problem is that once a defaulter is always a defaulter. That is
a proposition of law, isn't it?
Proposition, yes. The problem is there. So we are not at all against that. We just let them file a representation. We'll proceed it as.
What is the problem, Mr.
The
Thapa?
other
Filing an
aspect is
application to the bank.
Notices which are under challenge is issued by them. There's no, there's no requirement on our part to even file a representation. They can unilaterally withdraw it. The moment they withdraw it, keeping in mind the.
What is the notice? Just let us see. What is the language in the notice?
My Lord, Lordship will find that at annexure 53, page 53.
What is the procedure which gets these things, Mr. Thapa?
My Lord, there is a procedure which is prescribed, my Lord, under the RBI guidelines, my Lord. In order to declare somebody as defaulter, there certain requirement is to be met.
Okay.
In this present case, my Lord, it was not done at all. So therefore, we were.
So, but then, so far as that part is concerned,
that is over, my Lord.
That is over. Now,
since the impugned notices are from them, my Lord, there's no bar on them to unilaterally withdraw. The moment they withdraw, this matter becomes infructuous.
No, it's okay.
Can I
there is no bar for them to withdraw.
Absolutely.
But then, is there any procedure?
Can I suggest something, Lordship?
That I am not aware of, my Lord, because
my humble submission.
Yes, Mr. Can you give us what is just show us the procedure for withdrawal of the notice? What procedure bank should follow upon
Lordship, can I make a humble suggestion, Lordship?
Yes.
Give us 15 days time.
Okay. We can give you.
Time out. They can go they can go. If we do not do it by following the procedure, we will.
That is what. See, we want to know what is the procedure.
Because unless
if you say supposing you see, if you are sticking to that proposition that once a defaulter always a defaulter, okay, there is a known maxim of law, but then this also has application. You see, depending.
I understand. Not sure I do appreciate that is.
So what is that? So what about the thing? Now, if you say if your submission is that even for withdrawal of that notice, that certain procedure has to be followed. Please before us those procedures and accordingly.
No, not Lordship. That is between the bank and the RBI.
Yes.
The problem is that since there is a pendency of this case, Lordship, right? Kindly appreciate that point. We are not. Everything is finished. So kindly appreciate everything is there. They don't have to pay any dues to us.
No, that we understand.
We have even issued the no due certificate to them. We have already issued the no due certificate, Lordship.
Yes.
The NCLT procedure is over. The DRT procedure is over. Everything is over.
So it is whether that no due certificate is equivalent to the removal of the tag of defaulter.
No, Lordship, that can be because that is what we are trying to do it. Lordship, once they file a representation, that since you have issued a no due certificate,
No, see,
there is no
representation,
pendency of the cases.
we can understand,
take
we can
it up with
understand, you see.
RBI. Lordship, kindly let me finish, Lordship, please.
We can
Please,
understand
Lordship.
that, you see, but then the thing is that until and unless procedure requires filing of representation and consideration by a competent authority, why petitioner should be directed to go through that process?
No, it is not about direction.
If there is a requirement of procedure, then just tell us that yes, after
Because-
there are certain
because-
authorities
because-
before whom
because-
one application has to be filed, and he will pass order accordingly. You will
Lordship,
research before the
problem is that
procedure, then we will
she
direct.
is not only the one defaulter. That is the problem for us. This is
No,
nothing
but
legal.
okay, but
Lordship,
in
it's only
this present
technical.
cases, this present
This
case
is
is
only
concerning
technical, Lordship.
this present case is concerning only the petitioner. We are not concerned about others.
That is true. That is true.
And Mr. Thapa, what is
The
the
Lordship, then I leave it to your
problem?
good judgment, Lordship. I leave it to your good judgment.
Even we may
I'll
say,
leave it to
let
your
us
good
assume that
judgment,
there is no this thing.
Because
Malad, rightly followed from your Lordship, Malad. In
See,
case if there is a requirement on our part to file a representation,
Just
we'll
give
do
them
that.
a reminder. You just say that we have clear.
Yes, that's it. That is what I wanted.
What I'm saying is,
That is
Malad,
what
if
I
the
want.
rule
With the time
prescribes,
bounds.
if the rule
With the
prescribes
time
that
bounds,
certain,
with the time bounds.
we are not telling
as
you.
rightly followed from your Lordship, Malad, if the rule prescribes, we'll do that.
See, we are not telling you to go. with
Otherwise,
folded-
Malad, it's their notice.
Please.
Malad.
See, you do not go with folded hands. You just give them a reminder that we have cleared these things and all. So you withdraw this notice. That is enough.
Malad,
If they do not do it, then you can come.
Absolutely. Malad,
Yes, Lordship. That is what I'm trying to
Malad,
say.
senior friend here, Malad, he's seeking for 15 days time. Perhaps by that time something will come up.
Because
This is
pendency of
already
this
submitted,
liquidation is a
Malad. The
problem
matter
for
is
us.
already before the RBI and the bank.
Okay.
After 15 days, Malad, if they don't do, we'll come out with certain
So
reports.
we can wait for 15 days, and that will.
15 days.
No, Lordship, there is a problem, Lordship.
He's saying-
This is the problem, sir.
No, you said just now 15 days. Now you do not.
No, 15 days. What I am saying that they write it in their representation that you have to fear, and your Lordship can also make an observation in the order and make it very clear that since there is no dues, bank had issued no due certificate, there is no pendency of any cases in any other court except this writ petition which is being disposed of, and bank is to take appropriate steps within 15 days. That will suffice, Lordship.
Otherwise, Malad,
That is what I'm
instead of
trying to
making
say.
this matter so complicated, Megan, they can
No, I'm not
unilaterally
making it
withdraw the
complicated,
notices, Malad.
What is the notice?
I'm not making it complex.
Which will
I leave it
find
to
at
Lordship.
page 26, Malad. There's a declaration, Malad, made by the bank, Malad, terming us as a willful defaulter.
Where is that?
Your Lordship will find at page 26 and Annexure 3.
You are Madhu Bajaj.
I am Madhu Bajaj, Malad, at serial number 2. Declaration as willful defaulter.
It has not been notified, Lordship.
This is a notice issued by the bank.
Bank, Malad.
Respondent number?
This is issued by the senior branch manager, Malad, Bank of India.
Is the respondent number?
Respondent number. His respondent number 3, Malad.
3.
What this notice is?
Malad, here they say that Malad, the committee was set up and then the committee has come on to a finding that we were to be declared as a willful defaulter, Malad.
The word is you were to be.
The identification committee, Malad, I'll just take your Lordship to the relevant paras.
Yes.
By page 27, Malad. Paragraph 3. The identification committee has identified the following willful default. The unit has defaulted in meeting its repayment obligation to the lender even when it has the capacity to honor the said obligation. Despite our constant follow-up, the company is reluctant to regularize the account. Thus, the branch under the instruction of identification committee has issued a show cause notice, right letter dated so-and-so. The same was served on so-and-so. After examining your reply, the facts, documents and evidence, and also after having a
So
personal
there you have
hearing.
been declared default.
Yes, the identification commission has shown that you have committed the aforesaid willful
Okay,
default.
now what is the proof of payment?
Malad, it was, I think it has not been brought on record, Malad, because it was under a separate proceeding.
There is no dispute that it is.
There is no dispute. So
No dispute.
So entire amount stood liquidated.
Has been paid, my lord.
No, not entire, it's settled amount.
It is a kind of settled amount, my lord.
Anyway, that
But which is
whatever is
agreed
the
to by the
loan account stood this thing.
Stood closed here. Stood closed.
What is the correct language to say? When you say closure, do you say that entire debt took liquidated?
Yes, no. Since it is under settlement,
what is the correct language then?
Settled amount has been paid. Entire settled amount has been paid, and the loan account stood closed.
They will only settle the amount which is under debt.
No. We are not asking anything more. That's why no due certificate has been issued. Not only by us, but all consortium members.
That is the problem, you see. Until unless even for use of words, if we are having dispute, then it's a problem.
No dispute.
No, it is. You can always say that entire amount took liquidated after settlement.
Yes, Lordship. Yes, that is true. Correct, absolutely correct.
You have any submission?
My lord, my role in the matter is limited. Limited in the sense that I had only taken over the company, R&B Cements.
So you do not have anything to say so far as this.
His grievances are strictly as against respondents 1 to 3.
You've been made a party later, isn't it?
Yes, my lord.
You played this party later, just 1 hour. Okay. Hard landed counsel of the parties. And this petition, this writ petition has been filed by the petitioner. There are 2 impugn orders.
There are 2 impugn. One
is this page 26. What is it?
One is the impugned letter, my lord, by which we were declared as willful defaulter, and the other one is the list, my lord.
What is the list?
You will find at page 53, annexure 7.
This is what? This is. No, this is what?
That is, my lord, the names of borrower. This is a list of willful defaulters.
Yes.
And my name appear at serial number 291.
Here it's a different name, isn't it?
The names of borrower declared as
there are
willful
so many
defaulter.
names.
Yes, many names, my lord. I'm only concerned qua the petitioners, my lord, so far as this notice is concerned.
So what do you want? Your name should be deleted from here.
This notice should go,
be-
my lord.
Huh?
This notice should
But
be
this
expunged.
notice, though, see, it concerns many people. You are concerned.
Qua the
with this.
petitioners, my lord. Qua the
So it
petitioners.
means like your name should be struck off from this.
Struck off, my lord.
That is the only thing.
Absolutely.
you say? This writ petition has been filed by the petitioner challenging the action of the respondent number 1, 2, and 3 and declaring him willful defaulter by the impugned letter dated 16/4/2018 and also incorporation of his name in the list of defaulters dated 1/5/2018. Give a paragraph. This settlement took place during the course of this writ petition.
Oh, yes.
Yes.
Before the NCLT.
Yes, just say it. Yeah, just give paragraph. It is submitted by the parties that the entire amount of loan in relation to which the writ petition has been filed, stood liquidated after the petitioner and the bank authority arrived into a settlement.
Not the petitioner, Lordship, the company, erstwhile company.
After, just say, what is it? Just say. Last time.
Erstwhile company, RMB Cements.
Just say, do not say after a settlement. Just use the after. Do not say petitioner.
Yes.
After a settlement was arrived into in this matter, and the entire settled amount has been cleared.
Yes, Lordship. Yes.
Leaving behind no remaining dues.
Yes.
Give a paragraph. Mr. Kapal, under counsel for the petitioner submits that since this entire amount of loan, entire loan amount stood liquidated, the bank of defaulter attached to the petitioner also stand removed as consequent to the payment. The petitioner cannot be regarded as defaulter anymore. Then paragraph, Mr. Datto, Honorary Counsel applying for the respondent number 1, 2, and 3 submits doesn't dispute the submission. Made on behalf of the petitioner. However, he submits that there is a laid down procedure followed by the bank in case where a party is declared defaulter and subsequently the loan amount is cleared. He submits, then it's according to him, the proper procedure for the petitioner would be to submit an application to the concerned. Who will be the official, Mr. Datta?
The branch will do. They will forward it. The branch, the senior manager branch. Respondent number 3.
Yes. What do you say? Just say the proper procedure.
Respondent number 3.
Petitioner 2.
Yes.
Submit a representation to the respondent number 3. Who shall in turn will take the necessary action
steps
within a period of 15 days from the date of filing of the representation. give a paragraph in use. Say in view of the submissions advanced by the party, this petition is disposed of by directing the petitioner to file an application to the number 3. By reflecting therein the outcome of liquidation of the entire bank account, entire loan account. What for you do not want to approach him? You do not want to go with the. Huh?
My lord,
Anyway, just what is it? Just we make it just simpler.
since he has already submitted, my lord,
You just say you'll find an representation so and so. Inform him about the. But then the bank knows it. You do not have to inform him again.
absolutely, that is why I'm saying they can also withdraw it.
Why to have this? Why to have
Instead of me, my lord, I'm already reeling in
you
the.
make a decision, so that's okay.
My lord, that's why I was praying, my lord, if since my learned senior friend has already asked for 15 days time,
One or two lines.
something comes up, my lord,
No, but then you do not have to make and go and make you see like humbly
my
bend
lord, it
down
will
before you.
unnecessarily
He doesn't have to do this.
prolong the issue, my lord. If they
it's
withdraw
not
the
that.
application
I'm only asking for a
unilaterally,
time bound
my
manner.
lord, from their side,
Time
my lord,
bound manner.
Wait, please, huh?
the matter ends up. If they withdraw the notices from their side, my lord, the matter ends there.
No, then we do one thing. Just we'll say what we said. File a representation. This petition is disposed of. Directing the petitioner to file a representation. Question number 3. Requesting him. Question number 3. Yes, requesting him to withdraw the notice dated. What is that? Withdraw the impugned.
My lord, one is 16.4
Dated
and 27.1.
2018. And also for tracking of his name from the list defaulter dated.
This is 31, my lord, 31/3/2018.
Just one number 3. On receipt of such representation from the petitioner shall consider the same and pass necessary order. Removing necessary order by striking off name of the petitioner from impugned notice dated 16/4/2018 and impugn. But then, Mr. Thapa, this is very improper for a court, read court, to pass a direction directing the authority to consider, and at the same time direct him which way to consider. That is something should not be done in a writ petition. Just what we said. Just you say the last line. You just cancel from there. You just say response number 3. After receipt of such representation from so and so, from the petitioner shall consider the same and shall consider and dispose of the same within a period of 15 days.
From the date of the representation, from the date of receipt of the representation.
No, but then the thing is that if you may not do it, that is also one problem.
No, we'll do it, Lordship.
It appears, you see, it appears from the submission of the parties that there is involvement of ego between the parties, nothing else.
No, Lordship. I'm making it very clear, Lordship. That's why I'm asking a time bound. I've been instructed to submit a time bound exercise should be there. There's nothing wrong. We are not even asking for.
Yes, all right. It's all right. You see, just this paragraph, where you say it in view of the submission? I mean, isn't it? Yes, just there you say in view of the submission. It appears that now there exists no valid and present reason for treating the petitioner as defaulted anymore. Give a full stop. Then you say, hence this writ petition is disposed of by direction, giving a direction to the petition. Okay. All right. And then the last part, where we have this thing, shall dispose of so and so within a period of 15 days in the line of the observation made in this order.
If my learned seniors friends submission be recorded, my lord, to the extent what he has submitted today, that my lord, they are willing to strike off my name from the defaulter list.
How can I?
He has already submitted that before the court.
Direction is given, you say that there is no reason to keep your name.
My lord, the only problem is they may prolong it again.
Anyway, we'll just
once they are already satisfied.
Before this court signs thing, there may be, if required, then there may be one to. It's okay. Then just think
liberty may be given to us, my lord, in case. Liberty may be given to us to agitate in case.
Always remain. Just say before that you just say the representation of this thing. Then you say, needless to say, the petitioner will have the liberty to approach.
If the grievance,
Lordship, a small indulgence, Lordship.
If there remains
small indulgence, Lordship.
Any such. It's okay, but then these are all useless directions. Why you fight for? We do not understand. Is it that the lawyer has to always stand up and object to each other's submission? Is that the rule?
In case the grievance still remains unfulfilled, my lord.
See, needless to say, the petitioner will have the liberty to seek judicial redressal in the event if there remains any grievance.
Item number 10.
May it please, Lordship.
Yes.
Lordship, in terms of the last order, Lordship, we have effected steps on respondent number 8, Lordship. Service is still awaited, Lordship.
This is for what? This is for what, Mr. Chanda?
This is termination from service, Lordship.
And then what for? There's a new implicated party.
Lordship, the managing committee has been implemented.
Not implicated, well, they have freshly implicated.
That is what? So that means that there is a newly implicated party.
Yes.
So notice has to go to them.
Lordship.
But then has the notice thing has come? Service report has come.
Which service?
Not been received.
Lordship.
So we are awaiting for quite some time. So verify the status.
Lordship, we will verify it from the postal
Yes,
department.
the office note dated 5/7/2024 indicates that the service report on the respondent number 8 has not yet been received. The petitioner will verify the status of the service and file a service affidavit within a period of 2 weeks.
2 weeks.
List there.
Item number 16.